Dear students, in this class we are going to deal with the procedural aspects of anti-dumping and also the Indian anti-dumping provisions. And we dealt in the last two classes about the two requirements or three prerequisites of initiating anti-dumping. And what are the procedural aspects? Procedural aspects of initiating anti-dumping investigations are also very important, because imposing an anti-dumping duty on a particular industry means that that industry may vanish from the market, because they may not be able to withstand an anti-dumping action for a period of 5 years. And usually we will see that the anti-dumping action is imposed for how many years? What do you mean by sunset review? What do you mean by the special provisions for developing countries? What is the standard of review? And what are the special provisions available to the countries, the developing countries? And what are the Indian provisions? What is the Indian law to deal with anti-dumping actions in accordance with the anti-dumping agreement? This we will deal in the present case, and this is the last the class on the anti-dumping module. So, the procedural aspects we talk about, and you can see that all the entire process is started with an application. An application from whom? Application from the domestic industry. In the last class we discussed what exactly constitutes domestic industry. So, the domestic industry gives an application for imposing anti-dumping duty to the domestic authorities. So, the domestic authorities vary from country to country, but every 164 WTO countries have domestic laws as well as domestic authorities. It is the mandate of the WTO anti-dumping agreement. So, in accordance with the WTO agreement, anti-dumping agreement mandate, every country legislated upon provisions relating to anti-dumping, including India. So, I said an investigation is started with a written application from the domestic industry. So, then the authorities will see whether the applicants really constitutes the domestic industry, whether they have a locus standi. We will see that what is the locus standi of who is permitted, who is eligible to submit an application. Then the investigating authorities will do a preliminary information gathering or preliminary investigation, and also they will make a preliminary determination. After the preliminary determination, they may proceed with a formal anti-dumping investigation. And also you can find there can be response to the preliminary determination. The preliminary determination may be, there may be an interim order for price undertakings, for other interim measures, or any other kind of interim measures can be. We will see that what are those interim measures also can be taken, is imposed by the anti-dumping authorities. Then collection of evidences, investigation, the full investigation, visit of the exporting country, gathering data, verification of the information. Then there is a final determination, and we will see one by one elaborately. So, we said that everything is starting with a complaint from a domestic industry, and in certain cases, special cases, the anti-dumping authorities also can initiate, suo motu initiate anti-dumping investigations. So, in cases, for example, highly fragmented industries. So, the government of India can take a decision with regard to the highly fragmented industries which cannot constitute the major proportion of the products producing that particular product. So, the government have the discretion and it rarely happens. And also who can approach? Here it is not only the domestic industry, the percentage of support which is required for submitting a successful application is also provided in Article 5(4) of the anti-dumping agreement. So, the provision says supporting producers account for more than 50% of the total production, or the second criteria is the supporting producers account for more than 25% of the total production as well. So, that means these two criteria to be as a whole, the entire producers, supporting producers or support for opposition to the application, it should be more than 50%. It means that more than 50% of the support of the whole the producers is required. And also within that 50%, the supporting producers account for 25% of the total production. These are the two economic conditions which they put it for submitting an application to the authorities. And also it is not just one page application is sufficient. The complainant must produce some kind of evidence, not the conclusive evidence, but some kind of evidence with regard to dumping, with regard to injury to the domestic industry and the causal relationship link between dumping and injury. So, we saw the provision, simple assertion or declaration without evidence is not admissible. So, the information in the application should be reasonably available to the applicant. It means without any evidence, mere statement, assertion is not sufficient to start an investigation. The complainant must produce some kind of evidences, so that the investigating authorities can verify and collect more evidences and start investigation on the complaint. So, the initial examination, so Article 5(3) very clearly says that it is there is an obligation on the importing member authorities to examine before initiating any anti-dumping actions the accuracy and adequacy of the evidence supported by or submitted by the applicant. And also detailed examination, detailed data is not required, because it is very difficult to get detailed data to the complainant. So, even within the limited data which is available to the complainant to show the injury to the domestic industry, the investigating authorities should examine it, its accuracy and adequacy. It cannot be manipulated data. The accuracy and adequacy of the data should be examined by the investigation or investigating authorities of the countries, individual member countries. So, again it says that before initiation, the support, the degree of support of the domestic industry, and also it's what is the opposition. So, the provision says that it should not exceed 50% or support or opposition, more than 50% support is required, greater than 50% support is required. So, what is the support, degree of support from the domestic industry? It is not only domestic industry producing the same product, but like product, or who is the complainant, whether really they are the domestic industry, that is to be verified by the investigating authorities. So, the failure on the part of the investigating authorities to determine whether there is sufficient support or whether it is really constitute the domestic industry, it is an error. It is an error which will severely going to affect the entire investigation. So, the entire investigation is going to be held void if the investigating authorities do a mistake, an error in case of if there is no support prescribed by the act, or if there is no sufficient evidence to show that there is an anti-dumping is going on. So, this cannot be repaired later on, and this will vitiate the entire anti-dumping investigation. And then and also article 5(8) which provides that if the preliminary investigation proves that if there is no sufficient support from the domestic industry, or if there is no sufficient evidence of dumping or injury or the causal relationship between dumping and injury, causal effect on injury, dumping and injury to justify the proceedings, then the investigating authorities will discard, stop further investigation, or the application will be rejected. So, in the preliminary investigation itself, if the application for anti-dumping initiation can be rejected, then again you can see that it is you cannot investigate for years and years. So, article 510 very clearly mentioned about in the usual period of time within 1 year, that is 12 months, and in no case more than 18 months. So, it is very clear 1.5 years. So, the investigation period should not be more than 1.5 years, because if the investigation extends, this an anti-dumping investigation itself is going to affect the entire industry, because further nobody is going to import that particular product from the particular country or a producer, which is an investigation is going on. It means that an anti-dumping investigation can stop imports of a product from a particular country. An investigation, starting an investigation itself is sufficient to affect the industry in the exporting country. So, the act very clearly gives a deadline of 1 year and maximum of 18 months time. And what is the due process rights? Due process rights of the respondents. So, article 6 which talks about very important due process rights. So, the respondent as well as the complainant must be given an opportunity to present evidences in writing, and the respondent must be access to the files. So, the evidence is submitted to the investigating authorities. You cannot have secret dealings. So, you must have the respondent have the access to the files and right of hearing, and even to meet the opposite parties, which is known as confrontation meeting. The name itself is confrontation meeting. So, it means that both the parties should meet. There is a right to meet the other party to confront with the allegations. Then timely information, timely transfer of information, and also before imposing anti-dumping duties, definitive measures, a notice should be given to both the parties, and the determination of dumping margin. So, it means that neither the complainant nor the investigating authorities can deal very secretly and impose an anti-dumping duties. A reasonable opportunity of being heard is to be given to the respondent as well. So, the principles of natural justice is applicable in anti-dumping investigations. So, this is mentioned in article 6. So, it is very clear all the opportunities to be given to the respondent in submitting, whether it is in the submitting evidences or hearing oral hearing, meeting the respondent and to be heard before imposing anti-dumping duties as well. So, all the due process clause is to be complied with before imposing anti-dumping duties. Article 6(8) of the anti-dumping investigation or anti-dumping agreement is very important provision, because in most of the cases the respondents does not cooperate with the investigation authorities. Definitely these producers will be in another country and the investigating authorities usually go to the producing countries and ask for production of evidences or the production data or the export data, and in most of the cases, for example, in the countries like China, they never respond even to the notices. In that case, what you will do? The article 6(8) of the anti-dumping agreement provides that if the members fail to submit or refuses to access to data or necessary information or does not provide information within a reasonable period of time or significantly and which that must have significantly impedes the investigation, then the investigating authorities can go ahead with the anti-dumping investigation whatever available with the investigating authorities. That is article 6(8) is known as facts available provision. Even some of the countries interestingly submitted the data in a computer format which nobody can read. It has happened in some of the cases, so that they can drag. So, we are submitted. So, they can drag the investigations to unreasonable period of time. So, that is not acceptable. In that case also the investigating authorities will go ahead with facts available provision. So, facts available provision is a weapon in the hands of investigating authorities against those who are never submit data in time, or those who are not refused to submit, those who are not submit in time information, and also not responded also to the notices of investigating authorities. So, facts available provision gives the investigating authorities freedom to use whatever the data available with them against the respondent. And in the US Hot Rolled Steel case, the appellate body confirmed these kind of provisions in the domestic legislations. For example, the case of US the Tariff Act of 1930, which was the famous act which was enacted during the time of economic crisis or the Great Depression. So, they amended this particular act, and which required an inclusion of margins established partly on facts available in calculating the rate of cooperation or non-sampled producers was inconsistent with article 9(4) of the ADA. So, the story is very simple. So, they included a provision which says that we will calculate the dumping margin those who are differently for people those who are cooperating and non-cooperating. So, the appellate body said that this is a discrimination. Non-sampled producers, cooperating and non-sampled producers, this is a discrimination with regard to article 9(4) of the anti-dumping agreement. So, facts available provision also has to be used sparingly. So, the domestic legislations violating anti-dumping agreement will be held against the anti-dumping agreement and accordingly proceed with the members of the WTO. So, it is very clear you cannot have a domestic law which is overruling anti-dumping agreement provisions. So, we said that after the preliminary investigation, the anti-dumping authorities may impose provisional measures. And provisional measures, what are the provisional measures? So, here you can see that a public notice is to be given to that particular effect on provisional measures, and before imposing provisional measures, and opportunity to be given, opportunity of hearing to be given, and also us to submit documents and comments. And also there must be affirmative determination of dumping, affirmative determination of injury, and affirmative determination of causal link as well. And also finally, the investigating authorities should identify that this and also come to the conclusion that the imposing these provisional measures will be preventing injury, further injury to the domestic industry. Otherwise, unnecessarily the provisional duties cannot be imposed on the exporting country. And what are the form of provisional measures? So, the provisional measures are in the form of provisional duty. So, article 7(2) says that it may not be in provisional duty imposed, but it can be in the form of security, security of cash deposits or bonds or any other format of deposits, and take an undertaking that I am not going to continue with this particular the measures, this price, or I am not going to continue with the dumping. So, the provisional duty should be calculated, and these provisional measures, for example, the cash deposit should be equal to as that of the provisional duty. So, you cannot charge huge amounts, but you can only ask for to the equal to as that of the provisional duty to be deposited by cash or by bond or by other receipts or depository receipts with the authorities. So, provisional measures include the provisional duty and also cash undertakings or price undertakings, we can say. So, before the final duty, the anti-dumping authorities can impose provisional measures as price undertakings. So, it is very simple. The exporters undertake to align their export prices to the normal values. And also you can see that they agreed to suspend the exports in the dumped prices, and the price undertakings or the price increases, should not be exceeding the margin of dumping, even though you are free to increase the prices. So, if you are always most of the cases your complaint will be that they are selling it in a lower price. So, the price increase also should not exceed exorbitant prices. You cannot ask them to increase the prices exorbitantly, but you can only ask to the extent of margin of dumping. So, the price increases must be below the margin of dumping or sufficient margin to remove the injury to the domestic industry. So, and also the other factors which we discussed earlier, if the other factors are responsible for the problem or other factors are responsible for the finding of dumping, then it cannot be considered. So, the price undertakings cannot be taken, or the provisional measures should not be imposed on the exporters. So, then in certain cases the investigations are leading to the final measures. So, and also every time an opportunity of being heard to the respondent as well as the complainant and the verification of informations, sufficient time to be given to defend the case. What is the sufficient time? So, we saw that the total investigation period is 1.6 months in maximum cases. So, the parties cannot take 1 year period, ask for 1 year to analyze the data, you cannot take. So, the investigation authorities should give a reasonable period of time within these 18 months to submit data, otherwise they can go ahead with the facts available provision. And review of anti-dumping duties to be done from time to time. So, this time to time is usually 5 years, maximum period of 5 years. So, that means the sunset review provision or new shipper provision, which says that to the maximum you can impose anti-dumping duties to the tune of maximum 5 years, and even much before that also the states can do a review, but maximum. So, until there is a review investigation is pending, so you have to done away with the anti-dumping duties within a period of 5 years. The anti-dumping duties to be terminated within 5 years. So, this assessment can be done with a request from the exporter or even request from the complainant by own initiative by the investigating authorities also can be done, but it is mandatory to done at the end of 5 years. No application is required at the end of 5 years. So, if they want to do it before, then they have to give a application. So, the sunset review provision is for 5 years. So, how the collection of duties, what are the provisions for the collection of duties? So, we talked about the lesser duty rule. This is nothing but when you impose anti-dumping duties, the anti-dumping authorities must look into the margin of dumping. The first rule is that they cannot impose more than the margin of dumping. 2, it is not necessary that you impose the full margin of dumping in order to offset the dumping. So, you can put a lesser amount also, you can impose a lesser duty as well to remove the particular dumping. So, the lesser duty rule should be applicable. So, under the lesser duty rule, the authorities, the anti-dumping authorities must be imposing a lower duty than the margin of dumping, which is an amount which is adequate to remove the injury. And article 9(3) very clearly says, so anti-dumping duties may not exceed the margin of dumping. So, in any case, no case you can impose anti-dumping duties more than margin of dumping. So, if more duties are collected under the provisional measures, so you impose the actual amount of duty and a refund must be made of the excess duties, normally within 12 months of the request, and again that also in no case more than 18 months time, because the period of maximum period of investigation. That means, under the provisional duties, if you are collected a higher amount than the margin of dumping, then the authorities must return the money, excess money already collected with interest. So, we have court cases in India that the Indian Supreme Court has ordered for, we will see some of the cases later on, ordered for return of this money with interest. So, the collection of duties are also under severe constraint. Then the question you ask, whether a retrospective effect can be made for the imposition of duties. Article 10 talks about the retrospective effect. So, the provisional duties as well as the final duties. What is the date on which the duties will be applicable? So, it says article 10 says that the date on which the determination of dumping, injury and causality have been made. So, whether it is within the period of 18 months investigation period, when they do it, that is the particular date on which you can impose anti-dumping duties. So, but in certain cases, the injury can be done during the investigation period as well, and that also to be taken into consideration. So, in that case, if the dumping is continued during the investigation period, then the authority can impose a retroactive imposition of duties for the period of that particular investigation period. So, the imposition of anti-dumping duty is basically based on material injury and also definitely opposed to the threat of material injury or material retardation of the establishment of domestic industry. And also in most of the cases, the provisional duties are were imposed, the duties are collected from the provisional duties imposed. So, we already said that if excess duty is paid, you have to retain the excess amount. And article 11 very clearly says that the duration of anti-dumping duties. So, the provision says that as soon as possible a periodic review is to be made, and as soon as possible if the dumping is stopped or the price undertakings are made, then the anti-dumping duties to be removed. It means that if an exporter is submitted a price undertaking, then the country is to immediately stop imposing anti-dumping duties or continue to impose anti-dumping duties on the exporters. And how the review is to be done? So, as I said that the maximum period is 5 years. Either the domestic industry asks for a review or the exporter asks for a review, or the domestic industry to show that there is a recurrence of dumping in order to continue with the dumping duty. And duration termination is very important, termination of anti-dumping duties. We already said that the sunset requirement is 5 years, and also the review is to be asked by the domestic industry or by the exporter or even in certain cases by suo motu process of the investigating authorities, but no case than more than 5 years. And this 5 years is applicable to price undertakings as well. So, the sunset review provision is applicable to the 5 years, the provision is applicable to price undertakings, provisional measures as well. So, it means that no country can continue with the provisional measures beyond 5 years. So, you have to review and terminate. If you want to continue with the anti-dumping duties, then you have to do a review investigation and again find dumping, otherwise 5 years. And article 12, which talks about a public notice, not only for investigation and also finding of dumping, even preliminary findings, a public notice is to be given, because the purpose is very simple, the purpose is very clear. All the exporters and importers know that an anti-dumping investigation is started. That is why you can find the anti-dumping directorate website, all the initial investigation is recorded, is publicly you can find, and also the margin of dumping also to be revealed, and the reasons for determination by the authorities. So, reason for rejecting and accepting arguments and evidences also to be put it in the public place, in the decisions of anti-dumping directorate. So, a public notice is required with regard to, so not all the data, they are confidential informations, but initiation and ending or termination of anti-dumping duties or even price undertakings to be there, and the information should be in the public domain. Then we can see the some equations with regard to retroactivity. So, final duty, if final duty is equal to the preliminary duty, then you can say that it will continue. But if the final duty is less than the preliminary duty, the difference in the amount should be reimbursed to the respondents. And if the final duty is negative, the preliminary duty to be refunded. So, in the final determination, if the preliminary duty is refunded, or you can say that threat, if there is a threat is there, or threat may lead to actual injury, then also this amount can be retained, otherwise it is to be refunded. And you can say that, see, in order to implementation, as a part of the implementation process, I already said that every member country is obligated to form or legislate upon anti-dumping law in accordance with the anti-dumping agreement. 2. Arbitral tribunals, judicial authorities and other procedures to be in place for the prompt review of final determinations of anti-dumping authorities. So, anti-dumping authorities decisions has to be appealed, there must be appellate authorities, that is in the form of tribunals or in the form of judicial courts, judicial and arbitration or administrative tribunals. India, you can find the CESTAT. So, the Central Appellate Tax Tribunal is taking care of the anti-dumping cases, and this tribunal, the procedures must be independent of the authorities. So, it means that the anti-dumping authorities do the entire investigation and imposition of duties. In India, there is also a difference. It is very interesting. The investigation is done by anti-dumping directorate under the Ministry of Commerce. The finding of dumping also is made by the anti-dumping directorate under the Ministry of Commerce, and the anti-dumping duties. So, and they recommend it to the Ministry of Finance for collection of duties, and the Ministry of Finance can reject the recommendation of the Ministry of Commerce. So, it is happened in India. In some of the cases, the recommendations of the Ministry of Commerce to impose anti-dumping duties on certain products were rejected by the Ministry of Finance. So, ultimately the anti-dumping duties are imposed and collected in India by the imposition and collection is 2 ministries. So, it also increases transparency and also the review mechanism. And moreover, under the anti-dumping agreement, so India has maintained arbitral tribunals, the specialized tribunals are also there, and finally, the appeals can be filed before the Supreme Court of India, and only to limited extent they can go to the High Court at the period of investigation under the jurisdictions. So, this independent transparency, one is to maintain the transparency, and 2, the independency of the authorities, 3, the accessibility of 3 different the authorities, investigating authority, the appellate authorities, and also you can see the who is collecting and imposing the final anti-dumping duties. Article 17, which talks about special standard of review. in anti-dumping agreements. So, it says that a de novo review by panels placing limits on their examination of the evaluation of the facts by the authorities. That means, Article 17(6) oblige the panels to uphold permissible interpretations of anti-dumping provisions by national authorities in cases where such provisions permit more than one permissible interpretation. It means that there is a possibility of domestic authorities to interpret the provisions, and preference should be given to, if more than one permissible interpretation is possible, it is the authorities' interpretation should be given primacy. This is Article 17(6) which talks about special standard of review in anti-dumping agreement. And then special and differential treatment in anti-dumping agreement. Article 15, which talks about special and differential treatment for developing countries. So, it says that special regard must be, this is the language which is used, special regard must be given by developed country members to special situation of developing countries. But more than 300 cases are dealt by the panel so far, and 150 cases are dealt by the appellate body, and more than 6,000 initiations all over the world, and we could not find any special concessions are given to the developing countries. And also the provision says that Article 15 special and differential treatment provision says that possibilities of constructive remedies should be explored. So, if you are fighting in the panel or in the appellate body, what constructive remedies are explored? And also it says that constructive remedies should be explored before applying anti-dumping duties. It is not very clear whether the Act has mentioning about any kind of negotiation or any kind of mediation or any kind of other arbitration or even interference of any other countries like good offices. It is not very clear constructive remedies. So, what happened? Finally, Article 15 remains to be a provision which is in the anti-dumping agreement, where the developed countries never give any special treatment to developing countries. Even though the developing countries, for example, is many times India asked for the special treatment with regard to the concessions under Article 15, but no countries consider the developing countries. No concession will be given to the developing countries under the Article 15. So, the Committee on Anti-Dumping Practices, all the anti-dumping initiations, preliminary actions, final imposition of duties to be notified to the WTO Committee on Anti-Dumping Practices every 6 months. So, if an anti-dumping duty is imposed, action is taken, even investigation is started by 164 member countries, they should inform it to the WTO dispute settlement body. So, and this will be publicly available in the WTO anti-dumping site, so that it is clear that how many anti-dumping actions you are initiated. This is a part of transparency process. And there is a special standard of review under Article 17. Article 17 says that dispute settlement process is applicable to anti-dumping. So, that means DSU provisions, dispute settlement and understanding agreement, is applicable to anti-dumping provisions. It means that all anti-dumping cases will be subjected to the dispute settlement process of the WTO. So, here also saying that a special standard of review to be applied by the panels in examining disputes in anti-dumping cases with regard to both matters of fact and question of interpretation of the agreement. And another provision which we saw, that they should look into the positive evidence which is submitted to them, and objective examination of all the facts, not subjective examination. So, these provisions are, you can see that the language is very clear, but it is a vague languages which is already put forward. So, the degree of difference to the factual decisions, legal interpretations of the national authorities to be. So, we already said that if two interpretations are possible, the primacy to be given to the interpretation of the domestic authorities. And also you can see that the operation of the anti-dumping committee to be reviewed every 3 years, and also the activities of members with regard to anti-dumping to be reviewed 3 years. So, we can see that from for the last 27-28 years. For example, if you take India, the number of anti-dumping actions are increased, it never decreased. So, it means that the countries like India are highly protectionist in nature. They want to protect the domestic industries from goods coming from outside. In the name of anti-dumping actions, additional duties are imposed. So, we were talking so far with regard to the anti-dumping agreement. Quickly we will see what is the Indian law, Indian provisions with regard to the anti-dumping agreement. So, India has inserted certain provisions into the Tariff Act, Customs Tariff Act of 1975. Section 9A, 9B is incorporated, and also and it is these particular provisions are included. Remember, it is very interestingly you can see that these provisions are included, or a new law is enacted by India much before the WTO anti-dumping agreement. You can see the period 1982, India started anti-dumping investigations or included the provisions. It means during the Tokyo round or much before the Tokyo round of negotiations, India included anti-dumping provisions in order to protect the Indian domestic industry. Then again the amendment is made in 1985. So, and this 1985 amendment was to in conformity with Article 6 of GATT. It is very interesting. So, we can see the provisions, the customs tariff identification, assessment and collection of duty or additional duty on dumped articles and determination of injury rules, which was notified in 1985. So, that means even 10 years before the WTO the anti-dumping agreement came into force in 1995, 1985 itself, in accordance with the GATT provisions, India amended its law and inserted anti-dumping provisions in the Indian Customs Act 1975. So, in 1994 the anti-dumping agreement was established as a part of Article 6. So, again 1995 India amended its customs laws, and the new rules, the customs tariff identification, assessment and collection of anti-dumping duty on dumped imports and articles for determination of injury rules 1995 was notified. That means 85, then again it is amended in 1995, and also again the rules were amended in the year of 2000. So, that means after 5 years of the WTO agreement, again the rules were amended to provide or to give refund of duties which are collected during the provisional period. And you can see the provisions which was made in 2012, refund of anti-dumping paid in excess of actual margin of dumping rules 2012. So, remember anti-dumping agreement was in 1995, we made rules for the refund of duties in 2012 only, after 12 years. So, it made the administrative mechanism for refund of duties. So, what they have done with the collected duty from 1995 to 2012 is unknown, but the rules are passed in 2012 only. So, simply you can see that sections 9, 9A, 9B and 9C was inserted by the amendment in 1995 in order to comply with the WTO agreement on anti-dumping. And also you can quickly see some of the cases, what is the Supreme Court response on anti-dumping. The Supreme Court considered what was the object and purpose of this particular agreement. In the case of Reliance Industries Limited versus designated authority and others. So, the designated authority in India is Anti-Dumping Directorate General or Anti-Dumping Directorate, which was headed by the Directorate General of Anti-Dumping. So, the Indian Supreme Court said in this particular case, the anti-dumping law is a salutary measure which prevents destruction of our industries which were built up after independence under the guidance of our patriotic, modern minded leaders at that time, and it is the task of everyone today to see to it that there is further rapid industrialization in our country to make India a modern, powerful, highly industrialized nation. I can see this judgment only from the part of the protectionist agenda of the government. So, the Supreme Court very clearly says it is the duty of everybody to protect the domestic industry. I would say that as a big supporter of globalization, I would say that it is the duty of the domestic industry to be competitive in the international market. If you are not competitive in the international market, the goods will come from outside. So, if you are waiting for imposing anti-dumping duties, your domestic industry is going to be more non-competitive, and ultimately you may have one ambassador car like what is happened, and one day that also will vanish. So, and also we can see that the Indian authorities I was talking about, it is the Director General of Anti-Dumping under the Ministry of Commerce is the authority for investigation of all anti-dumping actions. All the appeals from the decision of the Anti-Dumping Directorate is to the Customs, Excise and Service Tax Appellate Tribunal, which is known as CESTAT from 2003 onwards. So, it is the appellate tribunal from the decision of anti-dumping authorities. And then I already talked about the anti-dumping duty investigation is done by the Anti-Dumping Directorate under the Ministry of Commerce, but the anti-dumping duties to determine, to decide whether to impose anti-dumping duties or whether to collect duties, the responsibility of collecting duties are with the Ministry of Finance in India, the two ministries. And quickly look into the Indian investigation process. It is similar to us that of WTO. You can see filing of application under Rule 5, then there is the initiation under Rule 5, again you can see initiation by the Director General of Anti-Dumping, then the filling of questionnaires under Rule 6, then there is a preliminary finding under Rule 12, then a disclosure statement, and there can be a final finding under 17 or levy of duty. Otherwise, in between the authorities can go for a visit, verification visit to the domestic industry of exporters. Mostly the Anti-Dumping Directorate people make a visit, whether they get data or not, it is it's unknown or it is confidential in nature. Then there will be a public hearing, maybe a public hearing under Rule 660 as well. Then provisional duty, either the provisional duties can be made, and after the levy of provisional duty, it may go to the final dumping, final findings, and then levy of duties can be finally made under Rule 18. So, this is very simply the investigation procedures and the imposition of anti-dumping duties and collection of duties under the Indian Act. So, you can quickly see some of the judgments of the Supreme Court of India, what constitutes. So, the Indian Supreme Court has clarified what constitutes a domestic industry. In the case of Lubrizol India Private Limited versus designated authority, so the tribunal, this case it was the tribunal observed that major proportion of the total production, So, which we saw in the anti-dumping agreement. The definition of domestic industry is also capable of being construed as to significant proportion or important part of the total production, which may not necessarily exceed 50%. So, the SESTAT has clarified the anti-dumping provision, what constitute or who is this domestic industry. So, and also you can see in another case also. So, you can see that in some exceptional cases the court has made the applicant comprised 27% of the total production. So, this is happened in the case of seamless tubes, pipes and hollow pipes of iron, alloy or non-alloy steel and other cast iron. From this is the case name. So, you can see that in certain cases 27%, the calculation comes to only 27%. So, the anti-dumping duties is country specific. It is not a common a duty is imposed on each and everybody. So, it will be depend upon the margin of dumping. So, the duty liability is different from one country to other country. So, it is very important to look into the rules of origin of that particular product. The product may be made in some US or something. So, if it comes to Sri Lanka and through the India Sri Lanka free trade agreement, if it comes to India, then the Indian authorities will look into the rules of its origin of this particular product. It is very important to look into, because all over the world the regional trade agreements and preferential trade agreements are proliferating like anything after the conclusion of WTO. So, the rules of origin to be looked into for the purpose of anti-dumping duty is also very important. So, in conclusion, I would say that the procedural aspect of anti-dumping duties are giving lot of leeway for the investigating authorities to determine the margin of dumping. And also there are provisions which talk about if the complainant nor the respondent did not supply sufficient data or information, then they can go ahead with whatever the information available with them, which is known as facts available provision. And more importantly, it is every country to decide whether to impose anti-dumping. Even though you find dumping, it is up to the countries to decide whether to impose duties or not to impose duties. So, the Indian law, which we saw the very preliminary provisions, we complied absolutely with the anti-dumping agreement and inserted provisions in 1995 as well. And I would say that successfully using this particular agreement as a tool of protectionism. That is why you find it that India is the largest user of this agreement in WTO, the largest user, and more than 1000 initiations so far from 1995. And another important thing also, and we foresee this particular the particular situation much before the WTO agreement in 1995, and we included provisions in 1982 itself. Then we amended provisions in 1985, and then last amendment in 1995, and some of the subsidiary provisions for the return of the excess collected duties in 2012. So, India is complied with the anti-dumping agreement, as well as India is and one of the highest use this particular agreement as a protectionist measure to save, in the words of Supreme Court of India, it is the duty of every citizen to save our industry. So, it is the duty, but at the same time I would say that we have to see very closely that imposing additional duty on each and every anti-dumping end and going with the the largest user of this agreement to be reviewed. Then only our industry is going to be a competitive industry rather than a domestic industry. Thank you.